This courtroom has seen countless cases, but today's story is different. A 21-year-old father of two stands accused of assaulting a pregnant woman, his former partner, who was close to delivering their child. What makes this case even more shocking, she filed an affidavit of non-prosecution, asking the court for leniency. But the judge isn't buying it. From custody disputes to no-contact orders, and a second defendant who's just 17 facing serious time for aggravated robbery. This episode is a roller coaster of emotional outbursts, tough justice, and personal reckoning. Stick around, because the judge's final words might just leave you speechless.
Counsel, have you received all the discovery? Did you review it with your attorney?
I have reviewed.
With your client.
Yes, Judge.
Court will find that the state is in compliance with discovery, showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Let's break this down. Assaulting a pregnant person isn't just a crime. It's a third-degree felony, and Texas law takes that extremely seriously. A conviction carries up to 10 years in prison and a $10,000 fine. So even if the victim is asking for leniency, the judge is obligated to weigh the severity of the act, not just the victim's wishes. This is where emotions clash with legal obligations. And that tension is exactly what's unfolding here in real time.
Yes, Your Honor.
So if,
She's requesting, and I'm sorry, Judge, may I speak?
Sure.
She's requesting it for her convenience. They've been doing custody exchanges for the last almost a year through a third-party person, and it's her request. She reached out to me, filled out an affidavit of non-prosecution, and requested that. So
I'm not following that. So if you all want to withdraw your plea now, you can, but I am not doing a no harm for injurious contact versus.
Now this is a major twist. The victim wants the court to allow contact for custody reasons, but the judge flat out refuses. Why? Because protecting a child doesn't mean putting the mother in danger again. The court isn't just making a ruling, it's making a statement. History of violence cannot be dismissed for convenience. What would you do in this situation? Should a judge ignore a victim's request if it endangers them in the long run? Let us know in the comments.
The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
we are, Judge.
Anything you wish to say on behalf of your client?
Judge, we would just request that you follow the agreement between the state and defense. Mr. Casillas is wanting to move forward in a direction that's appropriate for his children. He understands what went wrong, and he wants to take full responsibility for that. And he has had no issues since the arrest on this date, and they have been successfully co-parenting since that time. There was a CPS case, Judge, that was closed out for no finding.
All right. How old are you?
21, Your Honor.
How many children do you have?
2, Your Honor.
What are their ages?
1 year and 6 months.
1 year and what?
1 year and 6 months.
Are you employed?
Yes, Your Honor.
What do you do?
I work at Amazon at facility warehouse.
All right. So why do you keep hitting on Stephanie Ortiz? At one point, I'm assuming you loved her because you have children with her.
Yes, Your Honor.
So why do you keep hitting on her?
It was just me not being in the right state of mind, me letting my feelings get to myself and not just thinking right and thinking straight.
That makes no sense to me.
Your Honor, it was just my fault. I let my feelings get to myself, let her get in my head and
Let what?
let her get in my head, and I just reacted in a wrongful way.
No, but I mean, you're up here hitting someone. Honestly, I don't even know why I should follow this plea, but your attorney is telling me that she's filed a affidavit of non-prosecution. But according to this, she was pregnant and she was going to be induced that day, and you decided to put your hands on her. I don't understand. How is she getting in your head that you would be hitting a pregnant woman who's about to deliver your child?
Here's where it gets heartbreaking. The judge pulls from the police report bruises, swelling, burst blood vessels. And this wasn't the first time. Imagine being a child growing up in that environment. This is no longer just a case of assault. It's a story of intergenerational trauma in the making. The judge makes it crystal clear. If you love your daughter, don't teach her that violence is a form of love. Powerful and painful words. Can people truly change after something like this? Or is this just a cycle repeating itself?
There's to be 200 hours of community service restitution. That will be waived once he completes parenting classes, regular reporting by Zoom or in person, regular UAs. If you're drug tested today, what are the results going to be?
Positive. Your Honor.
And what are you going to be positive for?
No, negative, Your Honor.
Negative? Okay. So you haven't used anything.
No,
I think Amazon drug tests, do
yes,
they
yes,
not?
Amazon drug test, yes, ma'am.
All right, there's to be regular UAs. I'm going to want field visits one time every 3 months. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. Probation, is there anything else he needs?
You already did mention the regular.
Yes. All right, is there anything else you need from the court in order to be successful? 2023 CR 2528 and 2023 CR 2529, State of Texas versus Berlio Marquez. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Robert Maurer for defendant, Your Honor.
And are you Mr. Marquez?
Yes, ma'am.
Counsel, have you received the discovery in each of these cases and did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number I'm showing you was entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented in each cause number?
Only 17 years old and sentenced to prison for aggravated robbery. The judge doesn't yell, she pleads. Don't become institutionalized, she warns. This moment isn't just legal, it's deeply human. It's a call for redemption, even behind bars, and it's a harsh reminder of how fast bad choices can derail young lives. The real question is, can a teenager rise again after being thrown into the adult prison system? Or does this become a permanent mark that shapes their future forever?
The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, but asked to waive PSI.
Anything you wish to say on behalf of your client?
Just ask you follow the plea bargain here.
All right. And the cause number ending in 2528, the court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 2529. Taking consideration 2023 CR 2621, 2527, 699, 185, and 184. There's to be restitution, if any, to Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefevre, and also no contact with any of those parties. Pronouncing that name all sorts of ways. I apologize to Stephanie. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. How old are you?
17.
You're 17 and you're doing this foolishness. Things, if you want things, you got to get a job so you can have things. You understand?
Yes, ma'am.
For a 17-year-old, you've chosen a hard road for yourself because you're going to prison, 17. And you're going to be in prison with a bunch of people who are there for murders and other things. When you go to prison, don't become institutionalized. You're 17, you still have a chance to make something out of yourself and do better in your life. So keep your head down and do your time and try to improve yourself. You can even take college classes while you're at the prison. And if you dropped out of school and don't have your high school diploma, you can get your high school diploma while you're there. So don't come out of prison having just wasted time, okay? All right.
In this courtroom session, we saw two very different stories. A young father struggling with the consequences of domestic abuse and a 17-year-old whose choices landed him behind bars. The judge's firm stance on accountability, especially in cases involving children, stood out as a powerful reminder justice doesn't bend for comfort. From no-contact orders to emotional confrontations, this case had it all. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more powerful stories coming your way.